Welcome to Police Roll Call. I am Stanley Cohen. I am a former Cincinnati, Ohio police officer, and I taught law in the criminal justice program at Indiana University of Pennsylvania. And the goal on this channel is going to be to explain appellate court decisions that affect the authority of police officers to enforce the law on the street and in the court, and to enable the officer and the district attorney to defeat motions by defense attorneys to suppress evidence and to dismiss charges. And the case that I'm going to discuss today is Chrisiansen versus Eral. Now, in this case, an officer saw a person driving a car speeding at speeds of 85 to 90 miles per hour, and the person will not stop. Now, the officer was thinking about bumping the rear of the car to cause it to crash, to stop it. That way, when he remembered a police department rule, policy that prohibited bumping a car under the circumstances. And so it's at this point that there's a roll call question. And the question is, should the officer bump the car, cause it to crash, stop the car, and save motorists from possible injury or death? Or should he allow the car to continue on, endangering motorists and pedestrians? What would you do? Think about that. Well, the officer thought about it, and he decided to bump the car. He caused the car to crash. The driver was seriously injured, and he sued the officer in federal court. And the court had to decide whether the officer's bumping of the car was excessive and unreasonable or not. The driver was saying it was excessive and unreasonable on the ground that the officer violated the police department's rule and policy that prohibited bumping of the car under those circumstances. The court disagreed. The court dismissed the complaint, and the court reasoned as follows. A use of force by a police officer is not to be measured and judged by a police department policy or rule. Only the Constitution and judicial precedent evaluates the use of force as to whether it is excessive or reasonable or not. And so this police department policy cannot and will not judge whether the officer's use of force was excessive or unreasonable. In the court's opinion, the bumping of the car under the circumstances was not excessive or unreasonable force. It was force that was used by the officer to prevent loss of life by motorists using the road by this person driving at speeds of 85 to 90 miles per hour. So the case against the officer was dismissed. And that's the case of Chrisiansen versus Eral. If you would like to hear more cases like this in the future affecting the authority of police officers, subscribe below. And thank you for watching this video.